what do you say against something? If you have anything against relief sort?
As such, you have in your earlier responses.
No, sir.
So, if you have something new, then only you say something.
I say don't touch other issues, 3 issues. I say you say respond to prayer class.
Your Honor, may it please the Honorable Court, I am Speaker 2 from the respondent side in the case of Mr. Savamunde versus Minerca Minerals Private Limited. Continuing from where my learned co-counsel left off, I shall now address the court with the issue number 3rd and 4th. The third issue before the Honorable Court is whether the environmental clearance which was granted to Minerca Minerals Private Limited was arbitrary and unconstitutional. Moving to my submission, Your Honor, it is our contention that the environmental clearance was granted following due process under the Environmental Protection Act of 1986 and Environmental Impact Assessment Notification of 2006. The environmental concern which is raised by the petitioner are based on apprehensions rather than scientific evidence. The environmental clearance was granted by the Expert Appraisal Committee after rigorous environmental impact assessment. The precautionary principle has been integrated into the project condition and the onus of providing arbitrariness lies on the petitioner. Your Honor, my petitioners have argued the infringement of precautionary principle, but the respondent doesn't dispute the applicability of precautionary principle. In fact, the respondent embraces it. The environmental clearance was granted precisely. Your Honor, it is to be noted that the environmental clearance was granted precisely because the project satisfied the precautionary principle. A comprehensive environmental impact assessment was conducted and the clearance was granted subject to stringent conditions including compensatory afforestation, dust suppression, water management and rehabilitation. Your Honor, I would like to rely with the case law that is Lefish Human Mining Limited versus Union of India and other, where the Supreme Court held that the environmental clearance must be tested against the precautionary principle with judicial review. However, the scope of judicial review is limited to examine whether the decision-making process was lawful, rational and presently fair, not to substitute the court the judgment for the expert body. Your Honor, the environmental clearance which was granted to Minerca Minerals Private Limited was done by a specialized expert body, the State Environmental Impact Assessment Authority, after evaluating technical data, conducting all the site inspection and imposing condition. This court in its writ jurisdiction considered an appeal over the technical assessment. Judicial review is limited to examine the procedure, not just to examine the merits of scientific evaluation. Prior environmental clearance is mandatory and it was obtained. In the rely of this regard, I would like to quote the case of Supreme Court, which is the state of UP versus Gaurav Kumar, where the Supreme Court quashed the mining tender issued without environmental impact studies, affirming the mining lease required prior environmental clearance following site service. This follows the principle established in Deepak Kumar versus State of Haryana, where again the Supreme Court held that the prior environmental clearance is compulsory for all minor activities irrespective of lease size. Your Honor, the respondent has complied with the mandatory requirements. The environmental clearance was obtained before the commencement of the mining operation and petitioners are arguing for the suspension of the mining activities. That would lead to halt revenue generation for the state of Jharkhand. It could lead to unemployment among the workers and it could be breach contractual obligations with the downstream industries. Your Honor, in this regard, I want to rely on another case law, which is Narmada Bachao Andolan, where the Supreme Court recognized that the developmental projects of national importance can't be altered mainly because some displacement or environmental impact is inevitable. The appropriate judicial remedy is not suspension, but the imposition of additional safeguards respondent has done. And hence, in light of foregoing submission, the respondent most humbly and respectfully prevail before this Honorable High Court of Jharkhand that it may be pleased to first dismiss the public interest litigation filed by the petitioner, Mr. Sagar Munde, in its entirety. Second, declare the grant of 30 years mining lease to Miraki Minerals Private Limited is a valid and lawful exercise of the state's sovereign power over mineral resources consistent with the mines and minerals. Third, to declare that the environmental clearance granted to Miraki Minerals Private Limited is valid, having been granted prior to the commencement of mining operation in compliance with the Environmental Act of 1986 and Environmental Impact Assessment Notification of 2006. Fourth, decline to order the suspension or cancellation of mining lease, as such a remedy would be disappropriate and contrary to the public interest. Fifth, in the alternative, if this Honorable Court find any procedural deficiency, direct the respondent to comply with scientific conditions. Sixth, direct the petitioner to avail of the statutory remedies under the Forest Right Act of 2006 for the claim of compensation and rehabilitation. And the last is to pass such other and further order as this Honorable Court may deem fit proper in the facts and circumstances of the case.
Over?